Good evening, everybody. I want to thank you for inviting me here. I'm only sorry I couldn't be here in person to speak to you. For me, jury selection, which I'm going to be speaking to you about tonight, is one of the things that I spend most of my time with. It is, to me, at the heart of our Sixth and Seventh Amendments, and I think the jury system on the whole sometimes isn't given enough credit for being at the very heart of our democracy. Citizen participation, to me, is one of the things that we don't give enough credit to, especially in today's especially polarized political environment. For me, I've been involved in a lot of very high-profile cases, from O.J. Simpson to Casey Anthony, Aaron Hernandez, Phil Spector, Whitewater, Enron, Heidi Fleiss, any number of cases. And some of them have ended up with very surprising verdicts, and people have asked me a lot about that. And for me, especially these days, I see a lot of attorneys being incredibly reluctant to go to trial because they think juries are unpredictable. That's what I hear a lot. Juries are unpredictable. I don't know what they're going to do, so therefore maybe we should settle this case. Because we do, majority of our work is civil work these days. And the question I want to address tonight, which is really kind of at the heart of our jury system, is, are juries really unpredictable, or are they unpredictable in very predictable ways? And I believe that if we truly understand how juries work, how they process information, and how they decide cases, we can actually understand them better and try cases to them better so that we can do better risk evaluation about what cases to settle and which cases to try. So part of the difficulty comes in that we have, I think, an antiquated model of how we think juries should decide cases, which is this very strict that they only are considering two things: the evidence and the law. Evidence and law are the only factors that they use in order to decide the cases. And we know about human behavior and human psychology that obviously isn't true. Jurors have tremendous amount of information that they get these days from a variety of sources. They're on Twitter, they're on their social media, they form a bubble in which they reinforce all their beliefs about the world through their Facebook feeds and their Instagram feeds and all the social media and things that they do. They're also informed about the world by the news that they get, whether it be on Fox News or MSNBC or CNN or New York Times or any sources that they get. Those headlines and those particular inclinations do inform how they see the world. And finally, also, it informs especially their attitudes. And one of the things we do know these days is that jurors have become incredibly skeptical and highly judgmental and probably deeply disenfranchised from institutions, including our courts, but especially our Congress, our president, the whole political system, and even the Supreme Court, which has typically enjoyed a very favorable rating among the public, is also suffering as a result of the attitudes. So the challenge that we have these days is we have to think of jurors differently. And the new juror these days is disenchanted. They spend up to 7 hours every day on their devices, whether it be a laptop, a tablet, a phone. They also are used to controlling information themselves through a remote control or a mouse. So they have to, in trial, obviously sit and listen without that control for hours, days, and sometimes weeks on end, which makes it difficult. They have short attention spans because they're used to clicking on the very next thing when they get bored. They need visuals because we are a visual society these days. And obviously, trial is a verbal, rhetorical forum in which people speak and they have to listen, and that takes a lot of effort these days when people are used to pictures. Finally, jurors are only used to sitting in groups, sometimes at the movies, sometimes in classes, sometimes at their place of worship. And what that means is that they want to be entertained, they want to be educated, and they want a moral to the story. What this tells us is that jurors, instead of this strict file folder formula that we think of jurors, that they're just looking at the evidence and the law, they have a ton of different things that they use to actually filter and process a case, from their personal belief systems to their life experiences to their personality to their group dynamic, how they interact with other people, how they react to you, the way they like to get information. Some people are more visual, some people are more verbal, some people like to hold things in their hands. They often need to process information through a story in order to better understand a case. They have learning preferences. They fill in the gaps when the court instructs them that they aren't supposed to hear about attorney fees or about insurance in a case. They have direct knowledge about case issues. If you've got a car accident case, jurors are drivers, and they have their own rules about how they as a driver would drive on the road. They have certain ability to understand their own biases, and they are used to all kinds of information sources. So they use a lot of these different issues in order to really listen and formulate and hear your cases. So the truth about jurors these days is that they are inherently resistant. They're not just going to keep an open mind. They are going to test and push and make sure that the information you're giving them conforms with their own belief systems and their own attitudes and their own experiences. They want to learn more than they want to be persuaded. That tells us a lot, that if you can gain credibility by helping them understand your case more than that you try to persuade them. Their life experiences and beliefs often, obviously, form the filter through which they process your case. They use stories to actually understand and process the case. And they really work hard to emphasize and to comprehend exactly what your case is about and how to resolve those two different versions of what happened in the case. Overall, I give you this basic template because I want to talk to you about 16 different tips that I'm going to give you today about how to more effectively do jury selection to help you understand who your jurors are and how do you pick better jurors for your case. But before I do that, I want to talk to you about a basic question. And that question that we want to also ask in front of every jury selection is, how do we increase the quality of information that we get from jurors in the jury selection process in order to better form a cause and peremptory challenge? Because after all, your evidence is only as good as your audience. So two fundamental goals of jury selection. The first goal is to take a look at, to understand how those jurors are going to be using their life experiences and their attitudes in order to listen to your case. Not whether they're going to be using those, but how they're going to be using those. That's the first goal. The second goal is to form a relationship with the jury, to engage with them and to help them form a relationship so that they will listen to you openly and be more receptive to your case. So let's get into it. 16 different tips. The first tip is create a jury selection plan. A lot of times attorneys will come to me and they'll say, okay, I'm doing jury selection tomorrow. Who do I want on the jury? And I'll go, well, wait a minute. Is the judge going to allow you a questionnaire? Have you had to submit jury questions to them? How much time do you have in jury selection? How do they seat jurors in the box? How do they do hardship? How do they do cause and peremptory challenges? How many alternates are they going to have? All of these things are information that you need to find out well in advance. So in a pretrial conference, see if you can get this information, or call a clerk, or call someone who's done jury selection in their class, in their court before, and find out exactly how they've done jury selection in the past so that you can better understand and plan for it so that there's not a lot of unknowns on that day that you don't have to deal with. Tip number 2 is don't indoctrinate the jury. A lot of times attorneys will say to me, okay, I want to start planning my themes. So they formulate all their questions about how they want to plant their themes, and that has 2 adverse effects. Number 1, it identifies great jurors that the other side will then strike or use a cause challenge on. And 2, they don't get very much information about how to use their own peremptory and cause challenges. So don't waste that valuable time indoctrinating jurors. If you have to, save a couple questions at the very end and plant a couple themes. But for the most part, judges have cut down on jury selection for the most part because they don't like hearing the attorneys do opening statements in their jury selection process. 3, identify those juror attitudes and life experiences, whether it's employment history and attitudes towards former employers in an employment case, whether it's medical history or adverse or negative experiences that they've had with doctors or hospitals. If you're on the defense side, if they have negative attitudes towards plaintiffs or too many lawsuits, all these things are attitudes and experiences that you need to find out about. Identify them. For the most part, there should only be limited number, even in complex cases. Even in a contract case or a construction defect case, there's a handful. Identify those and formulate your questions around those experiences and attitudes. Then, number 4, create open-ended questions around those negative questions and experiences that you want to find out about. Because what you want to do is, if a juror's had a very bad experience with a doctor or a hospital, you want to ask them about it. Who here has had a negative experience? Tell me about that. What happened? What conclusions did you draw as a result of that negative experience? These are questions. Sometimes the vague and ambiguous question, while legally not good in examination, is good for a juror because it allows them to search for what is important in the information for them about that experience or that attitude. So create those open-ended questions, ask those open-ended questions. For the most part, I want you to apply the 80-20 rule. 80% of the time in jury selection should be jurors talking. Only 20% of the time should attorneys be talking. Don't worry about poisoning the panel. As you're asking about these negative experiences, I know it's difficult to hear. You're an advocate. You want to present your side's best case, and you want to convince those jurors not to have those beliefs and attitudes. But for the most part, you want to help them identify those things, because better out than in, finding out those negative experiences or attitudes allows you to more meaningfully exercise those cause challenges and those peremptory strikes. Like I always say, if done right, jury selection is an exercise in masochism. You really have to be tolerant of those painful responses and embrace them. Ask hard questions. If you've got a plaintiff in a case where they've lost a loved one, or they've had a serious injury, or they're a paraplegic, you're going to be asking jurors to make really hard decisions about liability, and about causation and about damages. Ask them those hard questions and don't let them off the hook. How are you going to make a decision when faced with the loss of a loved one? How much money to award them in non-economic damages? How do you think you'll be able to do that? That's a tough question. And don't let them off the hook. Pause. Don't fill in the gaps. Let them struggle with that answer, because that's the thing they're going to have to struggle with ultimately in deliberations as well. Embrace their biases. If they've had a negative experience with an employer or a doctor, or just as a driver in a car, embrace them. Thank them if they tell you that. If they've had a loss, tell them you're sorry. This is the time where you can make a connection with the jury, because especially if they've had a negative experience against something that might apply to your client, that will show that you're confident. You're not worried about their bias. You may strike them ultimately, but ultimately you're communicating to the rest of the jury, I want to hear from you, and I'm not afraid of how you feel about the issues in this case. I remember I was doing a case many years ago involving accusations that the police did a high-speed pursuit which ended in the terrible injury to a person in another car. And one of the jurors popped up and said that they'd had a negative experience with the police earlier. We said, what is that? They said, I was at a party, there was an altercation with a policeman, they beat me and took me in. Well, my client wanted to strike this juror, but I passed them a Post-it note and I said to ask them why and what they concluded as a result of that experience. And the juror said, I was an idiot. I drank too much, and I got in a beef with this police officer, and they responded, and I learned my lesson, and I've always been on the straight and narrow ever since. That juror ended up being on the jury. We got a defense verdict. And so finding that extra level of information actually is very, very important. Really listen to jurors. This is by far the thing that will build rapport with them and allow them to open up their listening to you. Because if you really listen to them, if you really acknowledge what they're saying and use their words and really look them in the eye, you'll make a contact with them which will open an avenue in which they'll be willing to listen to you during your case. Stay curious. Oftentimes jurors will give you the most minimal amount of information when you first ask an initial question. Stay fascinated. Be curious. Go, wow, that's really interesting. Tell me more about that. How did that affect you when that happened to you? When you're hungry for that kind of information, when you're fascinated, when you're curious with it, that will also communicate to the jury that you're interested in them. If you're interested in them, they'll be interested in you and your case. Also, watch carefully their nonverbal behavior. A lot of times, their bodies will speak louder than their words. So if you ask them a question about whether they're going to be willing to award a certain amount of damages, and they go, yeah, I guess so, their body's going to tell you they're reluctant. So you can ask them about that. Boy, you seemed a little reluctant on that answer. Can you tell me what that was about? Or if you're asking a question of a juror and the other juror rolls their eyes, ask that juror what that was about. So their nonverbal behavior tells them what they're really thinking, really feeling, and make note of it and ask them about it. Find out what their rules are. All jurors have rules. We all have rules about how we like our life to run. And even though the court gives us rules and the standard of care in a medical case is the rule about that, jurors have a list of shoulds and coulds, and these are things that the doctors should do. And you want to find out what those are. You want to find out what the rules are in jury selection, so ask them about that. Facilitate a dialogue. A lot of times we'll ask jurors individually questions and we'll sort of go down the row. But one of the things you can do is to ask a juror a question and then ask another juror a question and then ask them what they think of what that juror said. And by responding to each other, a lot of times you can see how they will deliberate with each other. You're actually facilitating a preview of deliberation in your jury selection process, because how they interact, whether they're going to agree with each other or disagree with each other, whether one person is going to be dominant, will tell you a lot about how that jury panel might work together to arrive at a verdict. That's a great preview because it allows you to understand whether you're going to pick what we call a high conflict juror, where jurors are going to fight with each other and compromise, or whether you're going to pick a consensus jury, which prosecutors need and plaintiffs for the most part need in order to get those 9 or however many jurors they need to get a verdict. They need jurors to get along. Now, one of the things you need to resist the temptation to do also is don't ask the can you be fair and impartial or can you set it aside question unless you're trying to rehabilitate a juror. Oftentimes we'll get that great bias out in the open, that negative attitude about product manufacturer or about somebody who's involved in a contract. And then we'll say, well, are you telling me it's going to make you biased, or are you going to be not fair and impartial in this case? And then the juror backs off of it and they go, oh no, okay, I can be fair. I can be absolutely fair. And I can set that aside. Well, you've just lost your cause challenge, and every cause challenge is precious in these cases. Preserve them. So again, don't ask that fair and impartial question or can you set it aside question unless you're trying to rehabilitate the jury, get them on there so the other side has to use a strike on them. When you're exercising your strikes, only target at first those high-risk jurors. Really figure out who's going to be the most damaging to your case, who's going to be the toughest juror on you, and then use your strikes on them first. Those are the opinion leaders, the high authority figures who you think are going to talk the most, who have the most prestige, and are going to influence the other jurors. a lot of times you'll see some jurors may be slightly negative for you. You may want to use a strike on them. You may have strikes to use, but target those high authority jurors, because unless you're certain that they're going to go for you, they can take a lot of jurors with them. So target those high risk jurors first. And then look at the whole panel when you're striking, because oftentimes we use all of our strikes, and sometimes we end up diluting the panel that was good for us. So sometimes we will look at our panel early on in the strike process, and you'll have one strike, and you'll have a second strike, and then you look up there and you go, I've got a couple of bad jurors who I was going to strike, but you've got a couple great jurors up there. Well, sometimes it's good just to pass at that point, because if the other side passes, you've got a couple great jurors who you think might carry your water for you, and then you don't have to worry. Don't worry about the ones that are maybe negative but aren't going to run the jury. They're going to listen to your high authority figures, your opinion leaders. So sometimes it's better to stop and preserve your great panel as opposed to diluting the panel by keep going. Finally, once you have your jury, look at them. Understand who they are. By listening to their words, by having somebody write them down, you can use their words that they've told you about their life experiences, about their attitudes, about how they think, what they think about medical care and hospitals and employers and drivers and contracts and drug manufacturers, whatever it is that you're dealing with in your case. Their words you can use in your opening statement, your closing argument, and in your examinations. Because when the jurors hear their own words spoken back to them, they're going to pay closer attention because it'll resonate with them. Tailor your case to the jury you have, not the case that you've always wanted. Why? Because there's really only two cases here. There's the case that you want to try, and there's the case that the jurors really want to hear. Finally, let me tell you this. Respect your jurors. Don't forget about them. Oftentimes we get into presenting our cases, we're focused on our examinations and on our jury instructions, that we sometimes forget about who they are. Pay attention to them, respect them, because they will treat you exactly how you treat them. With that, I really want to thank you for the time you've spent with me here this evening. If you have any questions at all, please feel free to give me a call at Decision Analysis. We're in West Los Angeles. You can email me at rgabriel@decisionanalysisinc.com, decisionanalysisinc.com, or contact me, and I'm happy to answer questions about your cases, or if you have any questions about the PowerPoint and the information I've given you this evening. Again, thank you very much for joining me tonight.